Hello everybody, thank you for joining me on this webinar. Today we are going to be talking about trademark filing in India. Before I begin, let me just introduce myself. I'm Indu Verma. I'm a lawyer admitted to practice in New York as well as in India. Our major practice area includes intellectual property. Our practice is diverse, so I need to mention that. So we practice in the area of intellectual property. We do practice in the area of immigration law, which includes immigration to the US as well as in India. We do corporate practice and estates law, law of wills. We are into family law practice too. Family law, we do get a lot of cross-border litigation issues like custody of children. We are also into litigation, and the litigation part involves both civil as well as criminal practice. The criminal practice, although, is restricted to the Indian courts. If you need to know anything more about me and our office, please log on to www.induvarma.co. That's INDUVARMA.co. So now let's begin the session. Today we are going to be talking about trademark filing in India, and this is a very beginner's course, so do not expect me to give a lot of sections or discuss case laws on this, because it's meant for absolute beginners who have absolutely no idea about what a trademark is and how to file a trademark in India. I've tried to make it as simple as possible to make it convenient for a layperson to understand the trademark filing aspects in India. What is a trademark? You would want to know what a trademark is. When you go to a store to buy, say, clothes, you have your preference of clothes. There are certain brands that you would like. Maybe you would go to a Gap store to pick up a cloth, right? I mean, your t-shirts or your denims. Why would you go to a Gap store? Because you recognize that Gap has certain kind of products. Okay, I'm not advertising for Gap, I'm just giving you an example. Similarly, you want to do a search on the web and you immediately go to Google to search, right? So you associate a mark, a name to a certain kind of product, certain brands. If you need to identify, say you have goods or you're providing services, and you need to identify your goods and services from that of another, you would need a name, a symbol, maybe a label. It can be a combination of words, it can be a combination of numbers. So a trademark can consist of a name, a symbol, a word signature, a device, a packaging model, a shape of goods, combination of colors, numerals, or a combination of all of these. So like I said, for instance, say you hear the word Nike, immediately what comes into your mind is a swoosh of the Nike, because that's what identifies the products of Nike to you. A customer always looks into what's catchy for a customer. That particular name or a signature of that particular company is what imprints in the mind of a customer. So it's that. Trademark is that item, that name, that word, which links your goods, your products to one particular item that you're selling, and which is distinctive from the rest of the products that's there in the market. So when you are looking to file a trademark, you need to look into the aspects as, is your mark, is what you're trying to file as a trademark capable of being graphically represented? Can you put into writing? Can it be shaped? Can it be printed? So is it graphically representable? That's the first question you should ask yourself. Second, does the mark distinguish your goods, services from that of another? Like, there are so many products, Say you're selling a pen. Now you call this pen A, and you're trying to sell the product A under the trademark A. You have similar pens being sold, or similar looking pens being sold in the market, but it could be called C. How do customers identify your pen? Because it's called A, they link the name A to that of your pen A. And they don't go by C because they know C is not that of A. Therefore, trademark, it's very essential that your trademark be different from that of another. How do you know if there is already a mark called A which is linked to a pen that is being sold in the market in anywhere in the world for that matter? You would have to do something called as a trademark search. How do you do a trademark search? Well, I will go into detail of trademark search and where all you have to look into in another webinar, but I'll just give you a basic idea of how the search is done. So in India, we do have journals where it is printed. All the trademarks get printed in a journal. So in the earlier days, you would have had to visit and check the journals page by page. But now, thankfully, everything is online. So you have a public database wherein you can just put in your name, and your name as in your the name that you intend registering, and do a search to see if anybody else is using this particular product. Then there are also databases provided by WIPO, and most other countries do have databases online to go check if this particular name is being used by anyone who produces pen in the market. So pen is just an example. So whatever your goods are, whatever your services are, you can just go ahead and check that to verify if anybody else is using the same name to sell the same product or similar product. Now, if there is nobody selling a similar product, you would have to still see, is there any similarity in any of the marks that exist who are selling similar product like yours? If there is extreme similarity, then you will have a problem to register this particular mark that you are intending to register. We'll come to those problems or what issues can arise at a later stage. Now, there are classifications provided by the registry under which you need to file these applications. So before you file an application, you would have to assess under which category does your product fall under. Say you are conducting a business and you want to register your name linked to that particular business. So if you need to register your name in trademarks, you would have to do that under the classification of services. There are about 45 classifications in the Trademarks Act. 1 to 34 falls for the goods. The goods fall under 1 to 34. Services would fall under 35 to 45. In which case the business as a classification advertising, business, etc. would fall under class 35. So if you wish to trademark your name, your business name under services, you would have to do that under class 35. After you do the search and confirm that there is no other conflicting mark. If there is a similar mark and you think you've been using this mark for a longer period of time, there is an option of something called prior use. You can establish a prior use because you have a goodwill in the market. Much before this other mark was registered, you can always file an application and convince the examiner about how your mark is distinct and has a secondary meaning, has attained a secondary meaning, that anybody in the market is now linking that particular goods to your mark under your name. And that can be shown by way of prior use. So after a checklist of application is done, now you need to know where to go ahead and file it. In India, the jurisdiction has been provided to different sectors like southern, northern, western, eastern regions. So as far as the state of Maharashtra, Madhya Pradesh, Chhattisgarh and Goa, the filing would have to be done in Mumbai, the trademark registry in Mumbai, which is around Top Hill. The state of Gujarat, Rajasthan, Union Territories of Daman, Diu, Dadra, Nagar Haveli would have to be registered in Ahmedabad. The state of Arunachal Pradesh, Assam, Bihar, Orissa, West Bengal, Manipur, Mizoram, Meghalaya, Sikkim, Tripura, Jharkhand, and Union Territories of Nagaland, Andaman, and Nicobar Islands will have to be done in Calcutta. The state of Jammu Kashmir, Punjab, Haryana, Uttar Pradesh, Himachal Pradesh, Uttarakhand, Delhi, and Union Territories of Chandigarh fall under the jurisdiction of New Delhi Registry. The southern region falls under the jurisdiction of Chennai Registry. The states that fall under that are the state of Andhra Pradesh, Telangana, Kerala, Tamil Nadu, Karnataka, and Union Territories of Pondicherry and Lakshadweep Island. So this is where you would have to go and file the application. If you're filing in a hard copy form, there's a paper form. There are two options of filing. One is via hard copy at the registry itself, or you can do that online. There is a difference between the fees that you would be paying if it's a hard copy and if it's not a hard copy. That's if it's an e-filing. E-filing is slightly cheaper in terms of cost than the hard copy. I'll come to the fees in the next session, the next slide. Now we'll talk about the forms that you need to fill out. So once you've identified the trademark that you want to, even if it's a logo, there are different kinds of mark. There's a logo mark and there's a word mark. So in case you want to file a device mark, which is a logo mark, you have come up with the design, you have certain color combinations. Now all of these will be represented in a label form, or you need to put that into the form called Form TMA and provide the details that are sought under the Form TMA. Earlier it used to be TM1, now in 2017 that has been modified, and the form is now called TMA, and it requires a little more information than what it used to be earlier. With the Form TMA, you're required to file a statement of prior use if required. Say you've been, like I mentioned before, say you've been using this mark for almost 10 years before you are actually come to the Trademark Registry to file it. People connect your mark to certain type of goods or services, and there's a bit of goodwill, a lot of goodwill, in fact, attached to that particular mark that is being sold in the market, or the services that are being provided in the market under that particular name. Therefore, you can always ask for a prior use consideration through an affidavit which is filed along with Form TMA. Along with Form TMA, the statement of prior use, you also have to file a power of attorney in Form TM48. A power of attorney would be required to be provided to the constituted attorney who would be handling your case before the Trademark Registry, unless you are representing yourself in the Trademark Registry. Now, who can file this form for you? One is that you yourself can file it as an individual entity or as a proprietor. If the form is being filed online, you would have to generate something called as a proprietor code, and you would also require a digital signature for the filing to be done online. This form can also be filed by a trademark agent. A list of trademark agents is provided on the website of the Indian Patent and Trademark Office. An advocate can also file this for you. Advocate is an attorney who practices law in India. Or you can provide a power of attorney to someone from your office or anyone that you would want to as a constituted attorney to represent you before the Trademark Registry whenever they require you to be present or handle the case for you. Once the form is filed, you have to provide the fees, and fees filing fees as on January 2020 is divided into the individual, startup and small entity are asked to provide 5,000 rupees as a hard copy filing fee, and e-filing fee is 4,500. I'll just repeat myself again. Individual, startup and small entities have to pay a fee of rupees 5,000 for hard copy filing, that is a filing at the registry. And if it's an e-filing, then individual, startup and small entity needs to pay rupees 4,500. Any other category, say a corporate or any other entity for that matter, would have to pay rupees 10,000 per application if it's done at the registry as a hard copy, or 9,000 if it is an e-filing. Now, this is where the filing completes. So once the filing is done, a receipt is issued by the registry and your filing work is done. Now, what follows after the filing? Although I'm not going into detail over here, I would like to give you a small brief of what follows the filing. The first and the foremost, if your trademark is acceptable as it is, then it would be accepted by the trademark registry and a certificate of registration will be issued without much of a problem. Within a span of like 3 months or 4 months, a certificate would be issued. However, if there is some objection that the trademark registry finds, the examiner finds, a first examination report will be issued to you. It is a show cause notice asking you to present your case. The presentation of the case can be through an affidavit or as written arguments to the examiner to establish why this trademark should be provided to you. Once the first examination report is issued and you file your reply, the trademark registry may issue a notice of hearing if the examiner feels that this particular case requires a hearing. They may issue a notice of hearing. You do have an option of seeking a hearing too. That's a different issue, in which case there are fees to be filed, etc. So here, if the trademark registry issues a notice of hearing, you are expected to be present before the trademark registry. You or your agent, attorney, etc., whoever it is, would have to appear before the registry and provide the sufficient proof that they ask for to show that your mark is eligible to be registered. If the mark is rejected, then there is no question of moving forward, right? I mean, it's over. Then you have to file an appeal. We'll deal with the appeal in a different webinar. So if rejection is done, it just ends over there. If the mark is accepted, then there is a step called advertisement before acceptance. That is, it is published in a journal. During the publication, there's about a 4-month period which is provided to other parties. This is a notice to the world, in fact, to show that there is someone who's applied for this particular mark, and before we provide the registration, we are publishing it for you to see. If you have an objection, come forward with the objection. If you want to oppose the application, come forward with the opposition. So once your mark is accepted on the day of the hearing, they say that your mark is being accepted. It means that it will be now published in a journal, and there is a timeline of 4 months for anybody else who would want to oppose this application to come forward and file an opposition proceeding against your mark. The opposition proceeding is usually filed if they find that your mark is too similar to theirs, or that there's a likelihood of confusion, or it's infringing upon their marks. So there are different reasons why they would come forward with an opposition. In case there is an opposition filed, then there is a step of opposition proceedings which will go on before the registration or certificate issuance, if at all there is a certificate being issued. If there is no opposition filed in 4 months' time, then this particular mark would be registered and a certificate will be issued, say within a span of 4 to 6 months. The timeline usually depends, it varies between 6 months to 3 years, depending on, if it's a contested proceeding or not. Once the certificate is issued, you are the owner of the mark from the time of application of this trademark before that particular registry, or in India for that matter. You also would have to know something about renewal of the trademark. The trademark is valid for 10 years from the date of filing. However, it can be renewed year after year, as in for another 10-year span, and the renewal will have to be done 1 year prior to the expiration date. The renewal form is called the TMR form, and it has to be filed along with the requisite fees for the renewal. So this covers the basics of trademark filing in India. If you would like to know any further details on, any particular aspect that's been discussed today, feel free to email us at info@induvarma.co. We'll be happy to help you. Thank you for being with us today, and we look forward to having you with us for the next webinar session, which will be held on 17th of January 2020. Thank you.